Hey guys, it's Melanie, and I promised I was going to do a little read-through and reaction video to the transcript of the very first COCKYGATE hearing. So that is what I'm going to do. This might be a long video, because it's not very long, it's like 40 pages, so shorter than the average romance novella, but it might take me a minute to kind of get through it and explain what's going on in it as I understand it. So yeah, Courtney Milan paid $300 or thereabouts out of her own pocket so that we could have this transcript, and people have offered to pitch in for it, and she has said, no thanks, I'm happy to do it. So she is an angel. To sort of quickly reiterate what this hearing was about, this hearing was not primarily about the validity of the COCKY trademark. The validity of the trademark was an issue to be discussed because it was relevant to whether or not the judge was going to take action, but that's not what he was making any decisions on. The purpose of this hearing was to determine whether or not the court was going to grant a temporary restraining order that would immediately place an injunction and prevent Tara Crescent and Jennifer Watson from publishing and promoting books with Cocky in the title in violation of the trademark. In violation of the trademark. So, and also to step in and squash Kevin's petition to cancel the trademark, which again is going through the administrative process at the trademark office. So, that's where we're at, that's where we start. To quickly summarize what happened in the hearing, so you don't have to go through this whole long-ass video if you don't really care that much about the conversation, but you should because it's freaking awesome, and if you're one of those people that absorbs information better when it's spoken, maybe this video will be helpful to you. I'm more of a reader type, so I can provide this public service to you. If you don't really care about some of the discussions and conversations that went on here, the outcome of the hearing was Kevin was immediately dismissed from the lawsuit, and the temporary restraining order was denied. That does not mean the case has been dismissed. The lawsuit continues, and if the trademark is determined to be valid, as I understand it, if the trademark is valid, then there is potential legal action to be taken against Tara Crescent and Jennifer Watson. We'll get to that in more detail a little bit later, because I know I have personally, and a lot of other people have, and even Jennifer Watson's attorney made this argument that she is a publicist. She shouldn't be held responsible for authors violating a trademark or publishers violating a trademark. All she's doing is promoting, but that does come up in the lawsuit conversation. It's called a hearing. The word is hearing. I don't know what's wrong with me. So, this transcript is fantastic. Again, it's on I'll link to it, but it's on Courtney Milan's website. So basically the very first so Chris Cardillo is a Felina Hopkins attorney. Cardillo starts out, he talks a little bit about, he's going on about jurisdiction, and again, because a core issue of this is whether or not the court even should step in on this issue at this point in time. So he talked about jurisdiction. The judge says, I'm not worried about that, and tries to get him to focus back on the issue here. Cardillo explains that Kevin was the one who filed the petition, and then they have a whole long conversation about process of service. If you are not familiar with it, when you sue someone or you take legal action against someone, you are legally required to, make a good faith effort to notify them through very specific channel. There's like every state I think has their own rules about how it has to be done, but you have to specifically notify them in a certain way, or your lawsuit can fall through, or it'll be like severely delayed because you can't really take any action against someone until you can demonstrate that you've tried, to get them involved in some way and notify them that something's going on. So, it pops up in, you know, pop culture, like Seth Rogen's character in Pineapple Express was a process server. Not every state requires that you have to send a process server to physically hand someone the papers. And it sounds like in this case, the judge was satisfied with being served through mail and email for these, for the defendants in this particular lawsuit. So, yeah, so they're literally just at this point talking about whether or not it is, people have been correctly notified, and Cardillo is insisting that he doesn't necessarily have proper contact information to correctly serve people, and he's trying to get that information. And he kind of uses that as a way to slyly bring up something that will come up later, that Tara Crescent is tough to get a hold of. He says, "For Miss Crescent, Your Honor, we have been unable to ascertain that is her correct name. We don't believe it is. We think it is an alias or pen name. We also have been unable to obtain her address, even though she is represented by counsel. Prior to this case being filed, counsel sent a letter. No shade against the court transcriptionist who had to type this up, like, right afterwards, and, like, during and after, like, there's gonna be some typos. That's just the way it goes. Counsel sent a letter to Mr. Pollack, the trademark attorney sitting to my left, stating that they represented her. We contacted that law office." And at this point, the judge cuts in and asks, "Is the petition for cancellation made by her?" Because he's getting confused as to what exactly is going on in this lawsuit, understandably. He's assuming that the petition to cancel the trademark has something to do with Tara Crescent, that she's the one who brought it. And Cardillo says, "No, the petition is made by Mr. Nipper, who is a California resident." And the court says, "Okay, so what are you going to do about serving the service of process for Tara Crescent and Jennifer Watson?" And they determine that the attorneys are going to accept any papers served to their clients. So Tara Crescent's identity and her address remains private at this point. And that's quite normal. Attorneys very often will accept service for their clients. So this is all, like, kind of administrative stuff, but it is notable that he's bringing up Tara Crescent and how he thinks it's an alias. They don't think that's her real name, because that will come up either later in this video or in a future video. I'm going to talk more about that issue. So at this point, the judge is satisfied that everyone has been properly served, and he's like, "We don't need to be talking about this anymore. Let's move forward. Everyone's been notified. We're good." And so at this point, Cardillo summarizes the case. He says, "We have Miss Crescent publishing 2 books infringing on the client's trademark. And also we have Kevin, who is referred to as Miss Knupper in this instead of Mr. Again, I'm not throwing shade. The typos are just funny. He filed what we believe is an erroneous petition to cancel these trademarks. And at this point, this is where a lot of people kind of got confused, and I honestly, reading the transcript carefully, I still didn't understand exactly what happened, and I've done some research, and I've looked at, you know, people's Twitter feeds and stuff of people that actually have legal knowledge talking about this issue, and I don't see an explanation of exactly what happened here. It's pretty clear to me that Kevin shouldn't have been a party in this lawsuit, because all he did was file a petition, which he's allowed to do. And it's not the judge's job to step in and block that. Unless it was, you know, really, I can't think of a scenario where a judge would need to step in and block. It's like the trademark office is dealing with it. That's their job. So, seemingly okay. I think there's something very important buried in this statement that I don't understand. The judge says, "I'm not going to stay proceedings before the evidence. You go ahead. Whoever wants to, go and do whatever you want to do there. It is not my jurisdiction. You go ahead. I'm not staying." I think, see, he says that in response to Cardillo explaining that Kevin filed an erroneous petition. I think that's a judge saying he's not going to get involved in the filing of petitions with the trademark office. I think that's what he's saying, but the sort of vague pronouns and stuff, you go ahead, whoever wants to go and do whatever you want to do there. He doesn't specify where there is. I think that's what he's saying, which would make sense as to what happens next. Cardillo says, "Certainly, Your Honor." The judge says, "How could you bring in the person who filed it?" And Cardillo responds, "We believe because he filed a petition without standing." In other words, he claims in his petition, and the judge cuts him off there and says, "That's a defense he makes there. It is not going to be a reason to bring in somebody else." Cardillo says, "Okay, Your Honor, we will withdraw that as to Mr. Knupper." And the court says Mr. Knupper is out of the case. At this point, it's so embarrassing that I haven't figured out how to pronounce this guy's name yet. Love you, Kevin. So that happens so quickly, and an author, I believe author, yeah, she's definitely an author, who was there at the time taking copious notes, Amanda Weaver. She said at the time, she's like, he got dismissed so quickly, Kevin was just out of the lawsuit, and I didn't understand whatever the legal reason was for that. I didn't understand. And I think it's because the judge was using that kind of vague language and rushing through it. He didn't really specify what he meant by what he was saying, and all those you and whoever wants to and do over there. But it does sound like he's just saying, I'm not gonna get myself involved in the trademark right now, because that's going through the trademark office. So at this point, Cardillo starts to say some tinfoil hat shit. So he goes, "As to Miss Watson," that's Jennifer Watson, the publicist, "at the time there was a secret," and I don't use that in terms of my own wording, but in terms of what was put out by Miss Watson, there was a secret movement called Cocktails, which we believe also infringed on our client's trademark. Miss Watson, as a publicist, we have learned, for Cocktails, has engaged other people and has requested that they infringe." The court says, that's, I'm assuming here that's not literally an entire courtroom speaking, that indicates the judge speaking. Pretty sure I'm right. The judge says, "So she has used your trademark?" Cardillo says, "Yes. Well, there is an issue of whether or not she used our trademark once we were able to talk to the attorneys. I don't want to misrepresent it, in the sense that she is not the owner of Cocktails. She is now, according to her attorney and declaration, only the publicist. However, as the publicist, she has clearly requested or promoted the idea of infringing on our trademark by telling people to write books with a cocky title in it." After registration, the judge says, "After registration, Your Honor." So she is in the case. Mr. Bosco, who I have to assume is Jennifer Watson's attorney, or representing her in some way, he steps in. "May I respond? Miss Watson has nothing to do with the authorship, production, or distribution. She did not request anything of anyone, and there is no evidence in the record that suggests she requested anyone to write for the book." And the judge responds, "As a publicist, she has responsibility not to infringe. If this is a protectable mark, she infringed on it." And there's a little back and forth on that, but ultimately he is saying something that was surprising, because again, even her own attorney was confident, arguing that she did not need to be involved in this case. She's not an author or a publisher. But apparently knowingly promoting something that might be trademarked is still potentially legally actionable. So the judge did allow her to stay as a party to this lawsuit when he did, like, he threw, sounds bad to say he threw Kevin out. He dismissed Kevin from the lawsuit, but not Jennifer Watson, because the promotional activity is still considered potential trademark violation. That was interesting. I don't think a lot of people necessarily saw that coming. At this point, Cardillo is requesting from the judge that one of those that I struggled to pronounce last time, declaratory judgment from the court, stating that the trademarks are valid and our client has a right to them. And the judge said, it's too early for that, not doing it. But this hearing, I will talk about whether I'm going to do the restraining order or the PI, which stands for personal injury. I believe that's what he's referring to, but let's see in more detail. So Mr. Cardillo says, "It is leased on the PI, Your Honor. We would like to enjoin Miss Crescent from continuing to publish her books using our trademark." And the judge, Miss Lackman, who appears to be, Miss Lackman is the attorney for Terra Crescent, goes back and forth with the judge a bit about whether or not it's a pseudonym. The judge says, "I can force you to tell me, so you might as well just tell me. Is it a pseudonym or not?" The attorney says, "Yes, it is a pseudonym." And there's the question of whether or not they are going to basically force her to reveal her actual legal name. And the judge says the first thing in discovery will be to reveal her name. You have no basis not to. To which Lackman replies, "Thank you, Your Honor. We would be amenable to deferring discovery to the extent this case proceeds." The judge says, "I can order discovery tomorrow. I can order a deposition of your client tomorrow. Why are you fencing with me? If you don't want to publicize the name, give it not to be used except for the purposes of this case and under seal." He's getting sassy. To which Lackman responds, "That would be what I would request, Your Honor, that we do it under seal." And the judge says, "Work it out with the plaintiff, and I will so order it." "Thank you, Your Honor." And the judge says, "Okay," this is not an actual quote, but he's telling Cardillo, "Okay, so we've determined that this is a real person with real representation. It doesn't matter what their legal name is right now. Can you just proceed?" And basically, this is a really interesting part for me because, again, I remember the Loris Cave lawsuit and how Jane Litt's real name and pen names and everything came out and all got tied together in the discovery process. And it's interesting to me that revealing stuff under seal is even an option because it didn't seem to me in that case. And I don't know the ins and outs of, why that happened then. And it seems like it's a possibility not to happen now. It seems like the judge is open to it, although a little annoyed about the back and forth on the issue of the pen name. But it's, generally speaking, there's no real legal reason why your legal name has to be publicized in order for, a lawsuit to go forward. Again, as long as the court knows who the person is. It's not important for the general public or even, the plaintiff to know the name, right? That's not really relevant. So, interesting, basically. Very, very interesting. This could be interesting precedent for future lawsuits involving authors who primarily use a pen name for their professional identity. So, at this point, Cardillo starts bringing forward Terra Crescent's book covers. And side-by-side comparison of Terra Crescent's book covers and Felina Hopkins' book covers. And the judge allows those to be put up as exhibits. And the judge is at first confused as to which books are by whom because they do look similar. I'll get more into that later. And they keep going. There's like a whole page of a conversation where the judge keeps going back and forth. He's like, "So books 2 and 3 are the plaintiff's books, the defendant's books?" He's like very confused by this. So at this point, the judge wants to look at the trademarks. He says, okay, and this is very interesting. Cardillo says, the judge says, so your client claimed the word cocky as standard characters without claim to any particular font style, size, or color. Cardillo responds, "That's correct, but there are 2 trademarks. My client actually owns 3 trademarks. I'm not sure what the 3rd trademark is. I guess there's only 2 that involve cocky." So he points out we also have the trademark for the stylized version. The court says, which came first, Mr. Pollock? I don't know who that is. Your Honor, they were both filed at the same time. The court, no, I want you to answer that, talking to Cardillo. They were both filed at the same time, Your Honor. The Cocky trademark, the stylized one, to my understanding, was used a little bit later in the series in terms of the style, the way it was written. But the format of the Cocky cover has been the same from the beginning. In other words, there's always been the word cocky above the other word in the center, large, bold type, etc. And so they just continue. The judge continues to try and understand exactly what the trademarks are and what Felina's laying claim to. And then he says the thing we've all been wondering. How can you trademark the word cocky? To which Cardillo responds, Your Honor, there are a few ways. The first thing is that in a series, the case law is very clear on this. You can trademark words like cocky without an issue. Second is when you say the word cocky, you don't necessarily think of anything that is relatable to the book except the book itself. So it identifies the book. It is definitely a source identifier in terms of what you think about. Miss Hopkins has 600,000 books sold so far, so this is a community that is well versed in her books and book covers and this trademark even before she filed it. To which the judge responds, so the defendants argue there is any relationship between the title cocky and the contents of the book. Cardillo says, I don't believe they do, Your Honor, but that would be erroneous. Cocky is a term used for this book as a source identifier for the series. That's the key. The key is that this is a series. We're looking to protect it in the same way that Star Wars was protected. The judge responds, if you can protect one, you can protect the series. If you can't protect one, the fact that it may be a series doesn't help you. Cardillo says, Your Honor, I'm not sure if I agree. The judge says, repetitive use. Cardillo says, I'm not sure if I agree with that. It provides a pointing to the source. If I want to buy another book in that series and I see the word cocky, I understand that now I'm buying a book in that series. The same way that if I was buying a book in the Twilight series, which is copyrighted. Copyrighted or trademarked? What does he mean by that? It would be funny if an attorney confused copyright and trademark. The judge says, in other words, you want to be able to prove there's a secondary meaning here because of the use of the series. Cardillo says, if the court wanted me to do that, I think I could do that. Doesn't sound very confident. But I don't think this requires secondary use. I think the case law clearly shows that it doesn't. I don't think cocky is, at least it is suggestive. When you think of cocky, you don't think of a romance novel. You might think of a bar fighter, a prize fighter, someone who has done very well in school. What? The judge says, you think it is suggestive of male prowess? Cardillo says, I think it is suggestive of, if you walk through a few steps, you would get to a romance novel. That is what we are protecting here, the use of the word cocky on the cover of a romance novel. Yeah, we know. The judge says it is, you said it was not descriptive of anything or suggestive of anything. It seems to me that it is at least suggestive of male prowess in a romantic situation. Cardillo says, I would say at the least we are in a suggestive category which is worthy of trademark protection. And the judge says, all these books have to do with the prowess of males? Cardillo responds, yes, but more important, all these books have to do with the Cocker family. The first 6 books were about the original 6 brothers, the next set of books were about their children. So we follow the Cocker family, they are known as Cocky. That's why Cocky is used in the titles. So they have like an entire family nickname. I haven't read the books. Is that an actual thing? Also, the defense argues that Cocker is the name of the series. That is not the name of the series. Judge says that doesn't prove anything. Anything else you want me to say on the validity of the trademark? Cardillo says not at this point. And the judge now wants to hear from the defense. And Cameron Ruber speaks on behalf of all 3 defendants in this instance. Before I get into what Cameron... Oh man, I sat in a bad position for my back. Holy crap, I'm getting old. Before I get into what Cameron said, real quickly to address this, because it's funny, the fact that they're interpreting cocky as being suggestive of male prowess, like, it clearly is a double entendre, and I think I may have said this in a previous video. I don't remember if I got into this yet or not. It's obviously double entendre, and we've been a little bit shy about admitting that. But more importantly, it's about arrogance, which is what the word means. It's like the actual definition of the word, and none of them seem to, like, get that, which is funny. Thankfully, it doesn't seem to be affecting the case at all, but it is pretty funny that's, like, a source of kind of confusion. So never mind. Mr. Ruber is not going to speak because Cardillo points out that he was representing Kevin, who's out of the case. And then Miss Lackman is asked to step in, and she does. So she says, the term cocky is used among romance writers. It's a common term in the industry. This is not like Harry Potter. And the term cocky has been used in connections with series well before the times that Miss Hopkins used it. And the judge says, it started out with Cocker Brothers. Lackman replies, exactly. If you look at the books as they were marked, you can see certain indicators of source here. I see Cocker Brothers being used consistently and independently. I also see Miss Hopkins' name. The term cocky is not used as an indicator of source, nor should it be. It describes the books. It describes the contents of the books, as do the books written by my client, who clearly labels her books with her name on top. Everyone knows that they are not Miss Hopkins' books, and who actually started using the terminology for books prior to Miss Hopkins. The question of the validity here, I think it is something that will be heavily fought, perhaps with a petition to cancel, but in terms of the strength, this is not the type of thing that can be used to censor other authors, especially those who have come before. And the judge's response is, it is clearly being used as a source, isn't it, indicating a source for the series of books, to which Lackman responds, as this shows, it does not show an indicator of source. If I look at this, I would not say cocky a trademark. I would say cocky is part of the title of this series of books. In fact, the titles change in every term. The title of the book is not Mother's Day by Cocky, or Mother's Day originated by Cocky. The title is Cocky Mother's Day, or Cocky Roomy. The source is Felina Hopkins, and it appears to be two books in the series Cocker Brothers, which was consistently used, and we don't challenge that. So out of anything on these covers that shows an indicator of source for Miss Hopkins, it is her name. It is the term Cocker Brothers, perhaps the series. For Miss Crescent, it is her name, and there are a series of titles. Trademarks are entitled to be used, and the judge cuts in, you're arguing looking at Exhibits 1 and 4, cocky roomy is an adjective. Lackman says, correct. Court says, and Cocky Mother's Day is what? Lackman responds, Cocky Mother's Day, cocky describes the contents of the book. It is an adjective that is descriptive of the book. To which the judge says, I don't see that. Let's talk about Exhibit 4, Cocky Mother's Day. There is no connection between cocky and Mother's Day. To which Lackman says, there may very well be. I haven't read the book, Your Honor, but there is an impression or suggestion here that based on the image that is shown, based on the genre, Cocky Mother's Day refers to some event on Mother's Day, or relating to Mother's Day, or mothers themselves, that might involve some male prowess. And she reiterates that, you know, someone shopping for books is looking at, you know, they understand the difference between author name and the title and the series title. The judge is stuck on Cocky Mother's Day. He says, Cocky Mother's Day is clearly not an adjective. Lackman says, no, it is an adjective of the book. And the judge says, if it is nonsensical. Lackman says, it describes the contents of the book. Book titles are inherently, as a matter of law, not protectable unless you can show they take a recess for 5 minutes. And they just kind of continue with this discussion. It's fairly redundant. And there's these, here the judge is trying to draw what he sees as the distinction between Cocky Roomy and Cocky Mother's Day. He says in number 1, which is Cocky Roomy, it shows a male stripped to his waist, tattoo on his arm, defined biceps, defined abdominal muscles, with a certain look of haughtiness. It seems to me that the title here, Cocky Roomy, is a description of the type of roommate this person is or this person has. As to Exhibit 4, Cocky Mother's Day, the depiction is of a young man in an open-collar sports shirt, various items of what appear to be a watch and cosmetic jewelry on his wrist, in a pose that also shows a certain haughtiness. What this has to do with Cocky Mother's Day is anybody's guess. So the cocky, I think, relates to the picture and is descriptive of the picture, but it may not have any meaning in relationship to Mother's Day. At this point, Cardillo steps in. I don't know why he's now speaking up, because I thought they'd put everything over to the fence to speak, but Cardillo says, it may or may not, Your Honor. I assume that the reader would want to buy the book and find out. Nice way to, you know, pimp your client's books right in the middle of this. The real question here is this a valid indicator of source? This also depends on a couple of other points, one of which is that she wasn't the prior user of this series of marks. Okay, this doesn't make any sense. Yeah, this is clear. There's an error. There's some type of error in the, yeah. This is, okay, there's some kind of mistake in the transcription here, and I wish I could untangle it. I wish I had read this a little more carefully before I started this video, because, like I said, I couldn't figure out why it was suddenly kicked back to Cardillo, because he was representing the plaintiff, not the defense, and the person in the transcript who is identified as Cardillo says, all these books that Miss Hopkins wrote were not sold under the term cocky. In fact, my client's books predate Miss Hopkins. So clearly this isn't Cardillo speaking. It might be Lackman. I would assume it's Lackman. But then after this whole, after like 3 paragraphs of who they've claimed as Cardillo talking, it then goes back to, oh, okay, no, I see. It's not as complicated of a mistake as I assumed. Okay, so what I think has happened here is they accidentally attributed this little, this string of arguments to Cardillo. They meant Lackman, because that's who's representing Terra Crescent. And so, yeah, Lackman says my client is not claiming rights to the term cocky. It's not a trademark. It's designed to entice the potential buyer into buying the book. It sends a message as to what the stories may be about. This is not a question of branding. And the judge responds, so in your papers you presented about a dozen instances of prior use of cocky in the title. And he mentions a book called Bite Me Cocky, which then Mr. Ruber steps in, and this is where I got really confused for a second, but Mr. Ruber, who's already been told he's no longer in the case since he was representing Kevin, who's no longer in the case, but he's still there, and he asks if he can speak up and correct a mistake that was in his brief since he's the one who wrote it. And he said, I want to be clear that the book Bite Me Cocky was, even though it was published in 2012, may not have been titled Bite Me Cocky at that time, that the title was changed in protest of COCKYGATE. And so the judge asked for clarification, so how do you explain the change, Mr. Ruber? As protest, effectively, that is our best guess. And Mr. Ruber says, in response to COCKYGATE registrations, yes, we believe the author added the word cocky as a protest. This is pure supposition on our part, Your Honor. We have only been doing this for about 48 hours. Cardillo cuts in at this point, and this is actually Cardillo. Your Honor, since this started, the COCKYGATE whole thing, the judge cuts him off, I know about that, but it is really irrelevant. Cardillo, the use of cocky and the infringement on my client's trademarks, if the court finds them to be valid, the judge says, let's stick to the point. Back to Lackman. Your Honor, we are not aware that anything else on this list is incorrect. So, again, the judge asked Cardillo to talk a little bit about his client's books. He agrees with the judge that Cocky Mother's Day clearly is not an indicator of any specific, description, because it doesn't make any sense. Here he gets to an important argument. By the way, to address Ms. Lackman's point about prior titles, I would point out that none of them are series. My client's is a series, which according to trademark law is very different than a one-off. To which Lackman responds, Your Honor, it is not correct to say that. Putting aside the minimal relevance, it's not correct to say there was no other Cocky series. There was a Cocky Cage Fighter series that came out well before Miss Hopkins. In 2015, the judge asked confirmation on that, and Cardillo says, Your Honor, we wouldn't dispute that you can use the word cocky in the Cocky Cage Fighter as an adjective. The judge says, case fighter? Cardillo, cage fighter, where you were fighting in a cage, a metal cage. We wouldn't dispute that somebody could use that. It's not what our application is for. Our application is very specific to the way we use cocky. Is it? Is it? Because she's been sending cease and desists to people who seemingly are using titles that are materially not any different than Cocky Cage Fighter. So I don't know why he's claiming that. So the judge is asking Cardillo here to confirm why he keeps talking about series, because it is barely mentioned in the trademark applications. So let's see. The judge acknowledges there may be a different standard in the patent law office than there is here in this court. And Cardillo keeps insisting they have no objection to Cocky Cage Fighter. You can use it in that sense as an adjective in a long sentence. What? And it is not used the same way Miss Crescent uses it, as a way to confuse the public and to direct readers to her series instead of our series. Again, how is Cocky Cage Fighter any different from the Cocky Doctors or any of the other books that Hopkins is taking issue with? I don't see how he hopes to get anywhere with this argument. And the judge seems to be similarly confused. He doesn't understand. At one point he accidentally says Cocky Firefighter, which I think is a book, but not one of the ones they're currently discussing. And again, the judge goes back to the fact that there is nothing about a series in the trademark applications except for that one. And and at this point the judge has, let's see, Exhibit E says the marks consist of standardized characters. That's correct, Your Honor. This describes the actual mark, Cardillo says. But in terms of what the class we applied for, they are both a series of books, whether they are ebooks or the traditional printed books. So we did apply for a series, and that's what we are trying to protect. The judge wants to move on. Lackman says, Your Honor, if I may. Judge says, no. And he's looking at what he calls the Polaroid factors, of which there are 8. Which measure likelihood of confusion. Okay, I'm assuming this has to do with the Polaroid trademark, probably. That is the ultimate issue in this. The first is the strength of plaintiff's mark. It seems to me at this stage in the litigation that it is a weak mark at best. The next factor is the similarity of plaintiff's and defendant's marks. I'm looking at Exhibits 2 and 3, Miss Lackman. What is the trademark? Lackman replies, my client's trademarks, if there are any on her books, are her name, and that is pretty much it. What I'm hearing from Mr. Cardillo is that he says there is no issue with the series of books called Cocky Cage Fighters, but my client can't put out a book called Her Cocky Firefighters. These are titles. These are not trademarks. The judge says, what is in the content of Her Cocky Firefighters? Lackman replies, it appears to be a male-female male romance. Beyond that, I imagine it involves 1 or 2 of the male characters is a firefighter. Judge says, in other words, it's descriptive of the contents. Lackman says, absolutely. Court asks the same question of Cocky Doctors. Lackman says, same thing, yes, same thing with all these books. Court says, 2 male figures. One seems to be wearing a stethoscope, indicating he is a doctor, but he is stripped to the waist. Lackman replies, doesn't look like my doctor, Your Honor. That's been featured as one of the highlights in a lot of people's Twitter feeds and such. So, at this point, Mr. Bosco, who is representing Jennifer Watson, okay, he now outright states that. And again, steps in to say that Miss Watson is an unpaid publicist. She doesn't control what anyone publishes. And the judge mildly chastises him for not providing a copy of the quote-unquote papers that Bosco apparently put together about this. And Cardillo tries to cut in. The judge tells him to shut up in so many words. He doesn't say shut up. I wish he would. So Bosco is specifically talking about Cocktails, the Cocky Anthology, and says it was intended as a form of protest and parody of Felina's attempt to monopolize Cocky. The judge is offered a copy of the book, says he's not going to keep it. I'll consider the title. Do you have a color picture of the title? What you're telling me is if Cocky is a valid trademark, then this is deliberate infringement. To which Bosco says, this is a deliberate parody, Your Honor. Just a minute. The judge says the cover cocktail is the Cocky Collective, will be marked as Exhibit A. So the judge is confused as to why there's a complete printout of the book page with all the reviews on it, because he clearly doesn't care about any of that. At this point, he allows Cardillo to respond to Lackman. Miss Crescent had worked with my client prior to publishing these 2 books, so to say that she wasn't aware of my client's use of the word cocky in her titles the way it is used, even prior to the application for trademark, is absolute nonsense. So he's pointing out something that we have known for a while now, that Tara Crescent and Felina Hopkins used to be, like, friends who would cross-promote each other. And the judge says the second factor in the Polaroid factors is the similarity. God, I can't talk. Similarity of plaintiffs' and defendants' marks. Cardillo says they are identical. I'm sorry, Your Honor. To which the judge says they are similar. But the third factor is the competitive proximity of their products. They are proximate and they are competitive. Fourth is the likelihood that plaintiff will bridge the gap and offer a product like defendants. Plaintiff is making these books with these titles, and defendant is publishing the same, whether it is protest or as an original offer. It is another factor in favor of plaintiff. Fifth is the actual confusion between products. Mr. Cardillo, you have 1 example of actual confusion. Cardillo corrects him. I have 3 examples. It is the last exhibit to my complaint, Your Honor. It is 3 emails or correspondence. I don't know if they are text messages or some other type of correspondence with my client. So he explains this is Felina has shown at least one of these before, a message from someone saying that they almost didn't buy one of her books because they thought another book with Cocky in the title was the same. And I've addressed this before. My personal opinion on it as an author, which is, yeah, there's always going to be some readers who get confused about things, but it's not representative of, like, readers in general. In general, readers can read and they can tell when someone's author name is different. Okay. These are actual communications, Cardillo says. These are consumers. In response to the judge asking, what is the source of this? He says, how do I know that? There's no address. Cardillo says, I believe they are pictures from her phone of the communications. I can certainly aver to the fact that they are legitimate. I don't know if that's a real word or a typo. On the first page, the third line reads, I assumed the book was part 1 of the series and didn't look further, that the authors were different. On the second page, I'm so sorry I shared the link for Cocky Chef. You're right. The reason I read it was due to your hard work, so sorry. The third page, hi, Felina. I just figured out how to return the book because the book wasn't her book. It was somebody else using her trademark. Your Honor, there is ample confusion in the community of the romance purchaser, but in general. Judge asked Mr. Bosco to respond to that. And of course, Mr. Bosco is the representative for Jennifer Watson, not Tara Crescent, so it's unclear. And he immediately says, this has nothing to do with Miss Watson. She's the publicist for the Cocktails Anthology, which isn't one of the books that has been demonstrated to be confused with any of Hopkins' actual books. So at this point, the judge asked to hear from Lackman. Admittedly, Cocky Chef is not my client's book. None of these instances relate to my client's books, and it is not even clear what these people were confused about. 3 instances. We are talking about purportedly tens of thousands of books. If it relates to someone else, I don't know. Again, this transcription was typed up very quickly, no shade, but there are some parts of it where it's confusing. The judge says, if it relates to someone else, has published a book with the title Cocky in it. There's clearly some missing words there. So at this point, Cardillo is asked by the judge to explain how these instances of confusion that he has shown actually relate to Tara Crescent's books, because that is who is being sued here. Cardillo says, well, I can't speak to that specifically, but you can see in the exhibits that Tara Crescent is making similar books, so it's possible someone could be confused by them, or it's likely someone could be confused by them. But as the judge asked him to confirm, the books that were cited as confusing are not part of the case. So he says, I cannot credit this as indicating actual confusion. The other instance that is mentioned is a reference on a web page or criticism is unreliable. No one knows who placed it, no one knows who sent it, nor the purpose. So I can't find that there are instances of actual confusion. Defendant's good faith. It seems to me, and I speak to Ms. Lackman and Mr. Bosco, that there is a lack of good faith. The titles and the layout have a lot of similarity. The issue really is whether they had a right to do that. To which Lackman says, I respectfully disagree. The layouts are consistent with all sorts of romance novels. I don't know how my client could have acted in bad faith if she used the term before Miss Hopkins did. I will come back to that probably in a future video. If anyone acted in bad faith, the judge cuts in asking for examples of the prior use, and Lackman says, our book came out in August 2017, and the first time Hopkins used her mark as a series, she used Cocker Brothers consistently. The judge says, we are not interested in Cocker Brothers. Lackman says, right. The judge says, what is the first instance of plaintiff's use of the word cocky? Lackman replies, November 18th, 2017 is the first time she used the term cocky and claimed that it was her trademark. The judge asks for confirmation from Cardillo, who says, that is incorrect, Your Honor. The trademark came after her use, but the use of cocky as you see it in those papers that I preserved you with color, preserved you with color photographs of the book dates back to 2016. It's in my papers, the exact date. I don't have it here. June of 16. The judge says, that is referenced in the registration. Right, Mr. Cardillo? That is correct, Your Honor. And Lackman says, basically all the people who came before Ms. Hopkins, if my client thought it was okay to use this term, because all these other writers have been using this term consistently since well before Ms. Hopkins claimed first date of use in 2016, judge cuts in all of this evidence of publicity and marshalling of other writers in the genre to use cocky on their books is indicating lack of good faith. Lackman says, my client is separate. My client is just an author. She is not agitating anybody or anything. In fact, she had a conversation with Miss Hopkins and she said, no, it's okay if you use cocky. In fact, Mr. Cardillo said it's okay if I use cocky as long as you don't use cocky firefighters. You can use cocky cage fighters. This is where this is all confusing. And the judge says, the judge basically just describes some of the book covers. Lackman says, yes, my client's name is prominently shown. And the judge says, the most prominent aspect of these titles, as you point out, is Miss Hopkins, the name of the author. Lackman, that's correct. Judge says, Tara Crescent. Let's hear Mr. Cardillo. Cardillo says, in terms of bad faith, Miss Crescent knew about these books, knew what they looked like, was helping promote them for Miss Hopkins, never had a title that looked like this before. When she saw the success of Miss Hopkins, all of a sudden created a cocky series, which she promotes the same way my client does. She calls it a cocky series. She takes the script font and the look of, the judge cuts in, where is that? I'd like to see that. Cardillo says, a cocky series is, I might have it in my papers, Your Honor, but there is proof in my papers in the complaint. Judge asks, point me to it. So at this point, Cardillo shows the judge Exhibit M, which is the correspondence in which Hopkins and Crescent are discussing cross-promoting their books. And he says that, so clearly Crescent was aware of the cocky series, and to continue to do her own cocky series in light of this is clearly bad faith. At this point, I think things have just kind of devolved into an argument between the two attorneys. Lackman just keeps saying, this is wrong, he's wrong, everything he's saying is wrong. And she argues that in the correspondence you can see that Cocky series, which is such a crucial part of Cardilla's argument, is not part of the title of the book that they are discussing, that Crescent and Hopkins are discussing in Exhibit M. So, Cardilla says, Your Honor, as the application for trademark, as my client's affidavit states, she was using cocky in the title in this manner since 2016. The court says that doesn't prove that the defendant had notice of it, because, again, this Exhibit M, the conversation was presented as proof that Crescent must know about use of the Cocky series, but Lackman has pointed out that it actually wasn't part of the title at that point, according to what's in the actual exhibit. So, again, more arguing back and forth between Lackman and Cardillo, and whether or not Crescent was aware of Hopkins' use of the Cocky series, or whether it was in use at the time. And because there's just a lot of back and forth, the judge says, I'm going to find that the issue of defendant's good faith cannot be resolved on the preliminary injunction. Now we're back to, I think, the Polaroid things again. Seventh is the quality of defendant's product as compared to plaintiff's. They are pretty much the same, aren't they? Cardillo says, Your Honor, I would say that my client has 600,000 books sold as of today's date, or approximately 600,000, to which the judge responds, that doesn't prove quality. A lot of people have taken this as some sort of like, ooh, snap moment, but it's just a fact. It's a question of a specific thing in trademark law, and how many copies you sold isn't relevant to what the judge is trying to determine right now. Lackman says her client has sold 300,000 copies of her books, and that's a neutral factor. So the judge says he cannot resolve that issue on preliminary injunction either. Eighth is the sophistication of the purchasers. This is why this issue was brought up in the original brief. You remember a lot of people were really upset about the classification of romance readers as unsophisticated consumers. That's why this was brought up, specifically because that is one of the issues here that the attorney knew was going to come up. It seems that the readers here are very well acquainted with these kinds of romance books, the judge says, and are very careful about who wrote them. I suggest to you that we have sophisticated purchasers here. Cardillo wants to take a step back on the likelihood of confusion. In a series of books, you don't have to prove confusion, you just have to show that there will be a liked. I don't know what that was supposed to say. Judge says, well, you never have to prove actual confusion, just the likelihood of confusion. If you can prove actual confusion, that is extraordinary proof. I don't think you have. All these 8 factors have to do with the judge's finding of likelihood of confusion. I am going through them one by one. I'm making a point with regard to the last of the 8 factors, the sophistication of the purchasers, that we have sophisticated purchasers. To which Cardillo says, Your Honor, if we can't use Exhibit P to show that there was actual confusion with Miss Crescent's books, I would point out to the court that Exhibit P at least shows that even though the readers are intelligent, there is confusion within the marketplace based on the way that these books are. The judge cuts him off. I'm not able to find that. So I can't find anything on that factor as well. It seems to me that the readers here are very specific to the genre of books, which I would call cheap romance novels, and so know what is going on and are not fools, particularly the way the titles are used. To sum up, the most important factor here, as we have gone through the eight, is the strength of the plaintiff's mark. It seems to me at this point of the record, and given the way that these titles look to be more adjectives than indications of source, that we have a weak mark. It is not clear that defendants use the word cocky in a way that makes it an indication of source. It is more a description of the nature of the contents. Her cocky firefighters, her cocky doctors. I hold the defendant is not using the word cocky in a mark. Although there could be a likelihood of confusion, other factors being equal, that there is some kind of infringement at this point, I don't think a similarity. Third is the competitive proximity of their products. They are clearly competitive proximate. The fourth is a likelihood that plaintiff will bridge the gap and offer a product like defendants. That is not really a factor because both are in the market already. Fifth is actual confusion. I didn't find any. Defendant's good faith, I think it is a mixed factor. 7, the quality of the defendant's product as compared to plaintiffs, they seem to be equal. Sophistication, at least at this point on the record, the sophistication of the purchasers, I think sophistication is high, and that is another factor against issuing a TRO or a preliminary injunction. Now let's talk about irreparable harm. Plaintiff will suffer irreparable harm if, assuming the trademark is valid, others will occupy the field. Although sales data can be obtained and damages can be proved, it is also a damage to goodwill involved in the trademark that can't be proved. So there clearly is irreparable harm that would be suffered by the plaintiff in the absence of restraint. However, it seems to me that the defendant, who is on the market with her romance novels, if restrained, would also suffer damage, and it would be irreparable. If a book is taken off the market, it can't be sold. Books of this nature have to do with timeliness as well, so I can't say that there is any balance here. If there is, it is unlikely to tip in defendant's favor, because a good portion of injury by the plaintiff would be compensable in damages and captured profits, so that factor is in favor of the defendant. Whether an injunction is in the public interest, given the way these trademarks are used, I don't think there is much of a public interest in them. Here, plaintiff can't demonstrate that its trademark merits protection, nor, in my opinion, the defendant's use of a similar mark is likely to cause consumer confusion. Those are the 8 factors that we just talked about. Accordingly, the motion for TRO and a preliminary injunction is denied. That doesn't mean the case is over. It means that we go into the next stage of discovery. I don't know if you were prepared for that, Mr. Cardillo. Cardillo responds, I am, Your Honor. Over the weekend, if Miss Lackman is available, I will coordinate with her. Okay, so they talk about more administrative stuff, scheduling, 3 months, September, I believe the date is September 7th. So they set September 7th, and for the date of completion of all fact discovery, the status conference will be held on September 14th. That was what I thought I saw. Okay, I'm going to plug in my phone real fast before my battery dies. Never mind, I guess I'm not going to plug my phone in because I just pulled the cord all the way out of the wall. So this video is nearly an hour long. I've gone through basically the whole thing, but I think the judge did a fantastic job of summarizing it, so I don't really have to. Basically, the case is not over, but he doesn't see any reason to take, you know, drastic, urgent action right now, which is what this hearing was really about. Generally, the legal system works extremely slowly. The only reason why this hearing was so quick is because they were, you know, specifically requesting things like a temporary restraining order, stuff that has to be acted on right away. And the judge is basically saying, no, we're not gonna jump to anything quickly on this. And I think the most interesting part of what he said was that although it is pretty clear that Hopkins could be damaged by potential misuse of trademark, Miss Crescent could also be damaged by being prevented from publishing too. So since those 2 factors balance out, he doesn't want to take any rash action right now. And that's basically where we stand. So yeah, this is an hour-long video. I have to stop at this point. It's going to take 10,000 years to upload. Hopefully this was helpful if there's anyone out there who has trouble getting through, you know, reading these legal documents. And I tried to just focus on the interesting stuff and maybe, you know, help you kind of absorb what's going on here. I will see you guys soon. I will be uploading, finally, my a reaction video to an old Felina Hopkins blog post from 2015 about how to give your man his balls back, which is great. Until then, bye.